Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Manslaughter Lawyer, Chicago, Illinois. Facing a manslaughter charge in Chicago, Illinois is a serious and life-altering situation. Manslaughter is a felony offense that can carry significant prison time, large fines, and long-term consequences for your record, career, and reputation. If you've been arrested or accused of manslaughter in the Chicago area, it's critical to act quickly and understand your legal options. The criminal defense lawyers at Combs Waterkotte can help guide you through this process, working with you to build a defense strategy tailored to the facts of your case. If you're dealing with a manslaughter charge in Chicago or anywhere in Cook County, Illinois, reach out at 312-500-HELP to start outlining your defense strategy today. Manslaughter Lawyer in Chicago, Illinois, serving all of Cook County. A manslaughter charge in Chicago, Illinois can quickly turn into a high-stakes legal battle. Prosecutors in Cook County aggressively pursue violent crimes cases like these, often seeking severe penalties that can impact your freedom, your future, and your reputation. You shouldn't face these charges alone. At Combs Waterkotte, we understand that manslaughter allegations can arise from complex, fast-moving situations where the full story isn't always clear. That's why we take the time to understand your side, carefully analyze the evidence, and build a defense strategy tailored to your case. Our team will thoroughly examine witness statements, police reports, and forensic evidence to identify weaknesses in the prosecution's case. From the outset, we work to have your charges reduced or dismissed whenever possible, and we're fully prepared to take your case to trial if necessary. If you're ready to protect your rights and fight back against your Chicago manslaughter charges, contact Combs Waterkotte online or call us today at 312-500-HELP. The sooner you act, the stronger your defense can be. Manslaughter definition in Chicago, Illinois. The Illinois Criminal Code is a bit nuanced when it comes to manslaughter offenses. Under Illinois law, there are essentially 3 different types of manslaughter offenses with which a Chicago or Cook County resident may be charged. Second-degree murder, which used to be called voluntary manslaughter. Involuntary manslaughter. Reckless homicide. The charge that the prosecution may choose to bring against a defendant depends on a number of factors, including their state of mind, their belief about the use of justifiable force, and even whether or not the offense was committed against an unborn child. Voluntary manslaughter charges in Chicago, Illinois. The Illinois compiled statutes used to have a standalone voluntary manslaughter charge on the books, but in 1987, the Illinois legislature reorganized the state's homicide laws under Public Act 84-1450, which was itself replaced by Public Act 95-1052 in 2009. What used to be voluntary manslaughter is now charged as second-degree murder under 720 ILCS 5/9-2. Despite its name, Illinois' second-degree murder statute aligns closely with what other states refer to as voluntary manslaughter. According to the state, a person commits second-degree murder while, when committing an offense similar to first-degree murder, they act under sudden and intense emotion caused by the person they killed. But the killing itself was accidental, or believe they used justifiable force in the killing, but the use of force was not actually justifiable. Like similar laws across the United States, it's the lack of premeditation or the belief that the defendant was acting in self-defense that separates second-degree murder from first-degree murder under Illinois law. For all intents and purposes, this second-degree murder law is Illinois' version of voluntary manslaughter. Illinois also has a specific statute for voluntary manslaughter of an unborn child that uses similar language. Acting under a sudden and intense passion that negligently or accidentally causes the death of the unborn child. Involuntary manslaughter in Chicago, Illinois. Under 720 ILCS 5/9-3, involuntary manslaughter is defined as unintentionally killing an individual without lawful justification if the acts which cause the death are likely to cause death or great bodily harm in most situations. The statute does leave out killings that come as the result of driving, instead calling those offenses reckless homicide. Another statute, 720 ILCS 5/9-3.2, uses very similar language to describe the offense of involuntary manslaughter of an unborn child. Reckless homicide in Chicago, Illinois. The reckless homicide law and the involuntary manslaughter law in Illinois are covered under the same statute, 720 ILCS 5/9-3. The difference is that reckless homicide is caused when driving a vehicle in such a way that uses an incline to launch it into the air. This may seem like an oddly specific offense, but the statute came as a response to injuries and deaths as a result of reckless, stunt-like driving in the state of Illinois. It's essentially Illinois' version of a vehicular homicide statute. The statute includes increased penalties for committing the offense in protected areas like schools, zones, and construction sites, and a separate statute, 720 ILCS 5/9-3.2, even covers reckless homicide of an unborn child. Manslaughter sentence in Chicago, Illinois. All of the manslaughter or manslaughter-type homicide offenses, charges in the Illinois Criminal Code, are felonies that carry potential prison sentences with them. The length of the prison sentence depends on the offense for which one is convicted. Both second-degree murder, or voluntary manslaughter, and voluntary manslaughter of an unborn child are charged as a Class I felony in Chicago and Cook County. A Class I felony conviction carries several possible penalties, including a prison sentence between 4 and 15 years, a possible extended term prison sentence between 15 and 30 years, a potential fine up to $25,000, 2 years of mandatory supervision after release, involuntary manslaughter of an unborn child, reckless homicide, and reckless homicide of an unborn child are all charged as a Class III felony in Chicago. If convicted, a defendant may face any of the following penalties: 2 to 5 years in prison, a possible extended term prison sentence between 5 and 10 years, a potential fine up to $25,000, 1 year of mandatory supervision after release. There are some instances in which reckless homicide may be charged as a Class II felony, primarily for offenses committed in construction sites, school zones, or in the presence of children. If convicted, an individual may face any of the following penalties: a prison sentence between 3 and 7 years, a possible extended prison sentence between 7 and 14 years, a potential fine up to $25,000, 2 years of mandatory supervision after release. Criminal defense strategies against Chicago, Illinois, manslaughter charges. Criminal defense strategies against Chicago, Illinois manslaughter charges. A Chicago manslaughter charge is a very serious matter. The best thing you can do if you're facing a manslaughter allegation in Cook County is to hire a criminal defense attorney. They'll be able to use their knowledge of the law to challenge the prosecution's case and protect your rights during interrogation. At Combs Waterkotte, we've helped defend Chicago area clients against manslaughter charges before. We've found the following criminal defense strategies to be some of the most effective in securing acquittals, charge reductions, and dismissals. Lack of intent, recklessness challenge. In Chicago and throughout Cook County, Illinois, involuntary manslaughter and reckless homicide charges hinge on proving recklessness. A strong defense strategy can demonstrate that the incident was a true accident rather than a conscious disregard of risk. If the defendant's conduct amounts only to negligence, not recklessness, criminal liability may not apply. Proving a lack of intent is critical in defeating involuntary manslaughter or reckless homicide allegations under Illinois law. Self-defense. In Chicago, Illinois, a defendant charged with voluntary manslaughter, called second-degree murder, or even involuntary manslaughter, may argue self-defense. If the defendant reasonably believed deadly force was necessary to prevent imminent harm, the act may be justified. Courts in Cook County carefully evaluate whether the force used was proportional. Defense of others. A defense attorney may present a defense of others argument when someone in Cook County or Chicago acts to protect another person from immediate danger. Illinois law allows reasonable force in these situations, even in cases involving reckless homicide or involuntary manslaughter allegations. If the defendant reasonably believed intervention was necessary, this defense can negate criminal liability by showing the conduct was protective rather than reckless or unlawful. Necessity. A necessity defense may apply in Chicago, Illinois manslaughter cases where a defendant acted to prevent a greater harm. In involuntary manslaughter or reckless homicide prosecutions, this could involve emergency situations requiring split-second decisions. Cook County courts assess whether there were no reasonable alternatives. If successful, necessity can justify conduct that would otherwise result in criminal liability. Coercion or duress. In Chicago and throughout Cook County, a defendant may claim coercion or duress if they were forced to act under threat of immediate harm. While limited in homicide cases like involuntary manslaughter or reckless homicide, this defense can still influence outcomes. Demonstrating that the defendant had no reasonable opportunity to avoid the situation can help reduce or challenge criminal liability. Constitutional rights violations. In Chicago, Illinois manslaughter cases, constitutional defenses are often crucial. Violations of Fourth Amendment protections against unlawful searches or Fifth Amendment rights against self-incrimination can lead to suppression of key evidence. In Cook County, excluding improperly obtained statements or evidence can significantly weaken the prosecution's case and potentially result in reduced charges or dismissal. Reducing charges. In Chicago, a defense attorney may seek to reduce charges for their client in manslaughter cases. For example, what prosecutors initially file as voluntary manslaughter, second-degree murder, may be reduced to involuntary manslaughter if intent is weak. Similarly, reckless homicide charges may be negotiated down to lesser offenses. By challenging evidence and highlighting mitigating factors, an experienced defense attorney can often minimize potential penalties and long-term consequences of a manslaughter offense. What to do if you're arrested for manslaughter in Chicago, Illinois? It's vital to understand your legal and constitutional rights if you're arrested for manslaughter in Chicago. If you exercise these rights correctly, it could mean the difference between a lengthy prison term and a complete dismissal of your case. The violent crimes attorneys at Combs Waterkotte recommend taking the following steps if you're arrested or charged with manslaughter in Cook County or anywhere in Chicago. Exercise your right to remain silent. If you are arrested in Chicago for voluntary or involuntary manslaughter or reckless homicide, do not answer questions without an attorney. Anything you say can be used against you. Politely invoke your Fifth Amendment rights and avoid making statements that could be misinterpreted or used to support the charges against you. Request an attorney immediately. After your arrest for voluntary manslaughter, second-degree murder, involuntary manslaughter, or reckless homicide in Chicago, you should ask for a lawyer right away. Do not discuss your case with police or investigators. An experienced Illinois criminal defense attorney can protect your rights and guide you through the legal process from the start. Do not consent to searches. In Cook County, law enforcement may seek permission to search your home, vehicle, or phone. You are not required to consent, so politely refuse and ask to see a warrant. Preserving your Fourth Amendment rights can be critical in manslaughter cases where improperly obtained evidence could later be challenged or excluded in court. Avoid discussing the case with others. After your manslaughter arrest in Chicago, avoid speaking about the incident with friends, family, or on social media. Statements made to others can be used as evidence in Cook County courts. This is especially important in involuntary manslaughter or reckless homicide cases, where your words may be used to establish recklessness. Comply with law enforcement without resisting. Even if you believe your arrest is unjust, do not resist. Resisting arrest can lead to additional charges. Remain calm and comply with officers so you can preserve your right to challenge the arrest later. Document what you remember. As soon as possible, write down everything you remember about the incident and your arrest. Details can become critical in defending against involuntary manslaughter or reckless homicide charges. Accurate notes can help your attorney identify inconsistencies and build a stronger defense strategy. Understand the charges against you. Manslaughter charges in Illinois can include involuntary manslaughter, reckless homicide, or what is often called voluntary manslaughter, but is charged as second-degree murder under Illinois law. Understanding what you are facing in Chicago or Cook County is essential because each charge has different elements and penalties. Early clarity will help you and your attorney plan an effective defense. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.